I kind of had something in mind of what I was going to talk about, and I'll get there in a couple of minutes, but I should say that as I was landing 2 days ago and flying across Colorado, the Rockies, and coming into Salt Lake, on my little monitor in front of me, on the seat in front of me, there was a CNN bulletin that the jury in the Libby case was about to render a verdict. And by the time I had landed, it turned out that Mr. Libby had been convicted on 4 or 5 counts. This was a case, unfortunately, that I was very involved in over the last few years, because it was a case that sent my client, Judy Miller, to prison for 85 days a year and a half ago. So my first reaction is that I was really pleased there was a verdict of any kind, because the last thing I wanted is for there to be a hung jury and a mistrial, and they would have to try the case over and have Judy Miller and 2 other Times reporters testify yet again in the case. I'm worried, quite frankly, and it was a case. There's an article actually in today's Times, if you happen to read it and take Corey's advice, that talks that the real loser in this case was the press, were journalists, because in the end the case presented the fairly unhappy specter of journalists testifying against their source, and now it seems, in conclusion, leading that source to go to possibly to jail, and certainly to be convicted. So it's kind of been an unhappy saga, and I'm not sure I agree that journalists were the big losers, and in fact I fear very much, that in the end Judy Miller, who was a recalcitrant witness, will have served more time in jail than the defendant who was convicted, which seems patently unfair. But beyond the fact of what this means to journalists, and maybe we'll circle back to that at the end of my little talk, it illustrates, I think, an unhappy theme or trend in recent years, which is a more and more confrontational environment between the government and the press. And while our system is built in a way to have some degree of antagonism, because after all it's the press that's supposed to be monitoring government, I think the amount of confrontation and the amount of antagonism between those two sides doesn't really do much for the side that both of those interests are supposed to be working for, which is to say the public. And I think to some degree the results of the election in November might be a signal that that maybe more conciliatory behavior is what the public wants, as opposed to the confrontation that we've seen. Now, the confrontation is best exemplified over the last couple of years in a story that the New York Times wrote a year ago, December, about the NSA's program to do domestic wiretapping, domestic eavesdropping, as part of its anti-terrorist campaign. The Times wrote an article describing this and basically saying that there were severe questions as to the program's constitutionality, that the requisite congressional oversight had been skipped, and that even the procedures that the government was supposed to follow with respect to warrants, which was very, very simple and quick, were being skirted by the administration, so that they were not getting warrants whatsoever. The result of the Times' stories was, on the one hand, that the NSA's plan was actually declared unconstitutional by a court, that there were congressional hearings, public debate, and ultimately the administration changed its protocol and procedures to do this sort of wiretapping. But at the same time that the stories had this sort of beneficial result, at the same time the administration went into a severe attack on the Times, with the president, the vice president, basically claiming that the Times' actions were traitorous, and the Attorney General threatening a lawsuit under the Espionage Act, charging the Times a violation of that act. That hasn't come about so far, and obviously I hope it doesn't come about at all, but the notion that the administration speaks so negatively and critically of what turned out to be a Pulitzer Prize winning report is, I think, should be troubling. Now, I should say at the outset that the Times didn't run this article, this series of articles, without a lot of concern and consideration. In fact, we've been criticized by the other side over the fact that we held this article for about a year, held it until the articles were made more solid, that we were more confident in them, and until we fully understood what the concerns of the administration were about our going ahead with respect to possible injury to national security and the national defense. And a series of meetings with government officials about their concerns was had, leading to a final meeting some weeks before we decided to publish, with the publisher of the New York Times and the executive editor on the Times on the one hand, and President Bush and the chairman of the NSA on the other. And at that meeting, Bush turned to Bill Keller, who's our executive editor, and said that if there's a second terrorist attack on the United States, he's going to have the blood of Americans on his hands if he goes ahead and runs this article. And that's a pretty daunting language and statement for anyone to hear from the President of the United States. Nonetheless, after a lot of consideration, and I'm sure after taking out some facts that we had that we didn't publish because we didn't think in terms of the balance between what's important for the public to know and what might be injurious to national security, I'm sure there are things we didn't publish. But in the end, we went ahead and published a series of stories. And as I just explained, that was the result. Now, I should say historically, as I'm sure many of you know, newspapers hold back facts all the time, hold back information all the time in the interests of national security and national security concerns. The presumption of any newspaper, of any media entity, is that we ought to share with the public that which we learn. I mean, that's our mission. On the other hand, that presumption can be overcome if responsible and high-ranking government executives can make a case that the information might be injurious. And indeed, there are two great examples historically that I probably should mention just because they're very interesting. One was back in 1961. You might recall that Fidel Castro became the premier of Cuba in 1959. And if you think back of who else were leaders of the world in 1959, my guess is that Castro is probably one of the only ones who are alive, let alone one of the only ones still ruling his country. But anyway, 2 years later, a bunch of Cuban exiles wanted to take back the homeland, and so with some degree of U.S. military assistance, they planned an invasion of Cuba. And the Times learned about that invasion and the fact that it was being aided by U.S. resources. And we were about to run an article when President Kennedy called the editor of the Times and said, look, if you run an article that this invasion's about to occur, these exiles are going to be, the enemy is going to be waiting for them, so please don't run this article. And the Times didn't run the article. The invasion took place, and the exiles got totally beaten up and repulsed anyhow. And later on, Kennedy was heard to say that he wished the Times had gone ahead and written the article, because then the invasion wouldn't have taken place, and this embarrassment to his administration, and this occurred just 3 months after he was inaugurated, would not have occurred. A year later was the Cuban Missile Crisis, and the President and the Times learned that that the Russians had sent missiles into Cuba. And the next day, Kennedy was to announce a naval blockade of Cuba. And the Times was about to print that the government had learned that the Russians were sending missiles to Cuba, which was fairly antagonistic since they were pointed at us from just 90 miles away. And again, Kennedy called the editor and said, look, I want to go on TV and announce what I'm doing tomorrow, and I don't want the Russians to have any forewarning that we've learned of this, that our intelligence has picked this up, so please don't run the article. And again, the Times did not. So while those are historic examples, I can certainly attest that there are a lot more current examples as well where we don't run information because the government has made a good case that doing so would injure the national interest. Now, all of this, everything I've talked about so far, has its origin and is mirrored by what really has been the greatest confrontation between the government and the press in our history. And that was in 1971 in a case called United States against the New York Times, more commonly known as the Pentagon Papers case. And let me tell you the story of that just for a few minutes, because it's a great and kind of fun story. Essentially, this was at a time when the country was divided, probably in a greater way than it had been any time since the Civil War, and certainly far, far more intensely and with more conflict than we see now in the division between red states and blue states, or people in favor of the war in Iraq, people against it. At that time, I mean, there was a generation gap. There was a civil rights movement. There was fighting over sex, drugs, rock and roll. And more than anything else, there was a severe conflict in the land about the propriety of our being in the Vietnam War. That was far heightened than it is today, because people like everyone in this room were susceptible to a draft. There was no volunteer army, and therefore the politics was that the upper middle class, who was much more vociferous than today, was really very actively fighting against the war. And so there was a great schism in the land. And from the point of view of a newspaper, to bring more and more information about the war in Vietnam, why we were there, whether we should be there, was paramount. And in the midst of that came along a guy named Dan Ellsberg. Daniel Ellsberg had worked for the Defense Department. He was called by Henry Kissinger the smartest student he ever had. And he was among 15 people designated by Secretary of Defense McNamara to do a history of the Vietnam War, to do a documentary history using government wires, government letters, documents of how we got into Vietnam in the first place. And Ellsberg worked on this project, and as part of that he went to Vietnam. And when he went to Vietnam, he got very disillusioned. He found that really the news that was coming from Vietnam, that the war was going well, was a lie, and that in fact the war was going hopelessly, there was no chance to win it, and he became very much anti-war as a result of this trip. And he's a very intense, very kind of conscious guy, and he decided he had to do something about this. And what he could do, what was in his ability to do, was to disseminate this secret classified volumes called the Vietnam Archive to the public so that they would learn more about all the mistakes that had happened that had gotten us mixed up in this quagmire in the first place. And he went to a number of congressmen, but they didn't want any part of this. It was just too hot a button to handle. And so he was depressed. And finally he went to a New York Times reporter named Neil Sheehan, who he had met while in Vietnam, and said, look, I have all these documents. You guys should think about publishing it. Well, Sheehan didn't really know what they were. He went up to Boston to meet with Ellsberg, got like, I think, 16 boxes, which he brought back to New York, get to buy 3 seats on the airplane shuttle to put all the boxes on, and arrived back in New York saying, hey, I got a great story. I got all these government documents that are classified that say about how we got in the war. You know, let's go publish it. And the editor said, you know, wait a second, we have to really think about this. So he sent 10 reporters into a secret hotel room to try to make heads or tails out of these documents. There were a lot of questions. First of all, Abe Rosenthal, who was the editor, later said, my biggest concern was whether this was a hoax perpetuated by Harvard students, and these really were hoax documents, not authentic ones. The Times reporters found they were authentic. And then they had to think about, well, were we going to publish the documents, or were we going to publish a series of articles in which we describe the documents? You know, maybe it was too dangerous to publish the classified documents themselves. And it ultimately was decided to do a little bit of both. Then they had to decide, do we publish it all at once, which has the advantage of not letting the government try to stop us from publishing, because it's all out there at one time. But it was decided that was kind of publishing with one eye on the sheriff, and that it was not a palatable way in which to transmit the information to our readers. So it was decided we would do it over 2 or 3 weeks in kind of an everyday series. Incidentally, today that decision wouldn't have to be made, because you could deliver it to your readers on a day-to-day basis, but at the same time dump the whole thing on the internet, and you know, the cat would be out of the bag. So that problem has kind of gone away. In any event, while this research and work was being undertaken by the reporters, a very, very vigorous debate was going on in the higher councils of the corporate sector of the Times as to whether to publish these documents at all. The corporate leaders were very fearful of the institutional harm this would cause the Times. First of all, we might be looked at as traitorous by our readers. We were very afraid that President Nixon would pull our FCC licenses for the TV stations we had. There were worries that we could be criminally liable for violations of the Espionage Act. And so there was a great deal of hesitation and caution put forth by the corporate and business side of the Times. Against that was the view of the newsroom that this was the most important issue in the land, and it was our job to transmit the information we had gathered to our readers. And ultimately, after a vigorous debate, the newsroom side prevailed. The publisher of the Times agreed to publish these documents, and the first document was published on a Sunday in June of 1971 in a newspaper that was essentially led by the news of the marriage of President Nixon's daughter, Julie, in a White House wedding, the first White House wedding that occurred in some 80 years history. Not much of a bang by this article. The White House, interestingly enough, it seems, was very happy about it because essentially it blamed for this morass in Vietnam the prior two administrations, that of Kennedy and Lyndon Johnson, both of which were Democratic. And since for Nixon, any news that was was bad for the Democrats was good for him, and so he was actually quite pleased about these disclosures. But after about 2 days, Henry Kissinger, his Secretary of State, told Nixon that Nixon and the executive branch was being made to look very weak by the fact that the Times was willy-nilly publishing classified documents, and he as the executive had to take steps to stop that. And so Attorney General Mitchell wrote a telegram to the Times saying, we want you to stop publication, and the Times wrote back, this was before emails and before faxes, wrote back a telegram saying that we respectfully will continue publishing for the same reasons that compelled us to start in the first place. And so that very evening, the lawyers for the White House basically served papers on the Times and filed in court papers in New York asking the Times to show up in court the next morning at 9:30 to explain why it shouldn't be held liable under the Espionage Act and why a judge shouldn't order them to stop publication. So that came to the guy who I guess used to have my job, general counsel at that time of the Times, Jim Goodale. And Goodale had been thinking about these issues for quite some weeks because he had learned that we were going to publish this. He had done some research into the Espionage Act. And he actually had gone to the Times' law firm of 70 years and asked it to do some research on this as well. And the law firm called Lord, Day & Lord, said, we don't want any part of this. We don't even want to look at these documents. We don't want to do the research because we think this is kind of a nasty business. We think we could be incriminated if we get these documents at all. These are classified documents. So we don't want any part of this. And now on the eve of having to go to court in what really was the greatest confrontation between the media and the government in our history, Goodale goes back to his law firm of 70 years and says, I really need you guys to go to court tomorrow morning. Can you start doing this work? We have to file a brief by 9:30 tomorrow morning. And they say, thanks but no thanks. We're not interested. We think we would be criminally liable too. We don't want any part of this. So Goodale had no choice but try to dig up another lawyer. As it happened, and this is kind of a funny part of the story, he was involved a week earlier in a luncheon with a Yale professor named Alexander Bickel, who was writing an amicus brief on the only case that the Supreme Court has ever decided dealing with the reporter's privilege. Now it's ironic because the reporter's privilege is the very issue that brought Judy Miller to jail in the Libby case, which ended 2 days ago. So there was this meeting about the reporter's privilege case of Brandsburg v. Hayes, which has become very apt in terms of the Libby and Judy Miller situation. And at the end of that meeting, Goodale, whose mind was filled with this Pentagon Papers possibility, asked Bickel a few questions about it, and apparently he liked the answer because at 6 o'clock at night, the day before we were supposed to appear in court, he said, well, maybe I'll get Bickel to be my lawyer. The only problem is he couldn't find Bickel. He had 1 or 2 numbers for him. He wasn't there. This was before voicemail. And so he did what a smart guy would do, is he went to the newsroom of the New York Times and said, find this guy for me. And it took him 10 minutes to find them in his grandmother's house on the west side of Manhattan. They got in touch. Bickle said, sure, I'll do the case. But he said, wait a second, you should know something. And he said, what's that? He said that I've never litigated a case before. I'm a law professor. I don't go to court. So Bickle said, Goodale said, that no difference. That's fine with me. But he said, I need a law firm to support me. And he said, okay, we'll get you a law firm. There's a guy named Floyd Abrams who has become kind of our leading First Amendment scholar and lawyer who works at Cahill Gordon, the firm where I used to work actually once upon a time. And why don't we get them to back me up? And he did that, and Bickle and Abrams met at, I think, 11 o'clock that night, and by 9:30 in the morning, they had a 15-page brief explaining their position as to why the Espionage Act was unconstitutional and couldn't be applied to stop publication in this case. On the other hand, the government needed a lawyer in New York also, because this case was being filed in New York, and the White House lawyers in Washington couldn't be the lawyers actually litigating the case in New York. So at 7:30 in the morning, a guy named Stephen Hess was awoken by a phone call as he was shaving, saying, we need you to go to court to defend the government's position in this case. And Hess had no idea what they were talking about, but said sure, and spent 2 hours as he was shaving and having breakfast trying to learn what was going on, and showed up in court at 9:30 to prepare the government's position. In the meantime, a wheel was spun in the courthouse, because whenever there's a new case, it's kind of randomly assigned, and there's actually a wheel that's spun that says who gets the new case. And in this case was given to a judge named Murray Gerfine, who had just achieved the federal bench. This was the first case he ever had as a judge. So you had a lawyer who's never litigated, an opposing lawyer who didn't know what was going on until 2 hours before, and a judge who never had a federal case before in his life. Worse for us, it turns out the judge had been a former military intelligence officer. It's not the kind of judge you really would want in this case from the Times' side. But they all arrived in court, and the first thing that happened was that the clerk came up and said, Judge, the government hasn't filed all the bureaucratic papers it has to file. They didn't file their $60 filing fee. You can't really start listening to them argue quite yet. And basically the most powerful guy in a courtroom is always the clerk, because he knows the rules, no one else does. And so there was a 2-hour adjournment that allowed Hess to learn what the case was about, and so on. But Hess had an additional problem, is that his clients were the White House lawyers, and the White House was saying that Hess can't read the Pentagon Papers because he didn't have the sufficient security clearance to do so. So for 4 days he argued the case without being allowed to look at the actual documents which are the basis of the case, because he hadn't passed through government clearances. So the case started, and basically there were two issues. One was the government said, well, the Times can't do this because these documents were classified. And the Times put in evidence showing that the White House menus were classified. And so the judge said, no, just because they're stamped classified, that's not going to do it. What I really need to see is whether the publication of the documents is going to harm the national interest. And so government witnesses went on the stand and explained how these documents, none of which were written in the past 3 years, so they all were historic documents, how these historic documents would actually harm the war effort or even the effort to arrive at a peace in Vietnam. And the judge, who probably started out being sympathetic to the government, was very unconvinced that these witnesses didn't seem to be persuading him that they were going to cause current disadvantage to the United States' efforts. 10 years later, it turned out, in an article that Floyd Abrams wrote about all of this, they basically conceded that they knew that it wasn't really harming the national defense, but their job was to say why it was going to cause harm, and they tried to do so. Well, Judge Gerfine, in the end of about a week's hearing, all of which was in closed court because this was all national security stuff that the government said couldn't be open to the public, decided in favor of the Times, and he did so in an opinion that I want to read a couple of paragraphs, because if you listen carefully to these paragraphs, not only are they beautifully written, but they really are, I think, very apt to today's situation dealing with the war in Iraq. He wrote, "The security of the nation is not at the ramparts alone. Security also lies in the value of our free institutions. A cantankerous press, an obstinate press, a ubiquitous press must be suffered by those in authority in order to preserve the even greater values of freedom of expression and the right of the people to know. In the last analysis, it's not merely the opinion of the editorial writer or the columnist which is protected by the First Amendment. It is the free flow of information so that the public will be informed about the government and its actions." These are troubled times. There is no greater safety valve for discontent and cynicism about the affairs of government than freedom of information in any form. This has been the genius of our institutions throughout our history. It is one of the marked traits of our national life that distinguish us from other nations under different forms of government. And with that, two things happen. One is that the Times won the case, at least this round of the case. But on the other hand, he ordered the Times not to publish because he wanted to give the government time to appeal. And so therefore, while on the one hand we won, on the other hand, for the first time in history, a newspaper, and by the way, we didn't publish while this hearing was going on, a newspaper was being ordered not to publish something, even though he was on our side. In the meantime, since we were stopped from publishing, Ellsberg was off running to Washington Post. He said, well, the Times isn't publishing this. Why don't you publish this? And so the Post started publishing it, and then the government stopped the Post, and then he went to the Boston Globe, and then they were stopped, and he went to the St. Louis Post-Dispatch. He ended up going to 18 different newspapers, all of whom were getting enjoined day by day, and then he would go to other newspapers so that the documents could keep coming out. In any event, in 2 weeks' time, which is a miraculous rate of speed, because usually a case from its origin to the Supreme Court might take 6 or 7 years, but in 2 weeks' time, the case was argued in front of the Supreme Court in Washington. And there, at that time, the Supreme Court had two justices, Justice Douglas and Justice Black, who were kind of First Amendment absolutists. They believed that when the First Amendment said Congress shall pass no law infringing freedom of speech, they really meant no law, and that the government simply could not stop the press from publishing anything, no matter what the circumstances. No other justices since have taken that kind of absolute position. But the other justices were not of that type. And so in the oral argument, the key from the Times' point of view was they knew they had these two judges pretty much in their pocket. They needed to get 3 more justices to have a majority of 5. And so the question came up in the middle of the argument to Mr. Bickel, who again was in his first case in his life. Mr. Bickel, what if these documents inexorably would lead to the death of 100 American troops? Would you say the Times has the right to publish them anyhow? And Bickel, as any good lawyer, said, well, that's not the case here. These documents won't lead to the death of 100 men. And the justice said, yeah, but let's take it as a hypothetical. Let's assume they would. Are you saying that the Times could publish these documents? And he paused and he ended up answering. He said, much as I adore the First Amendment, he said, my love of humanity is greater, and I would counsel the Times against publishing those documents under those circumstances. And that answer probably won the case, because it probably won the respect of the moderate middle judges, and we ended up winning 6-3. It also, however, led Justice Black to say it was too bad the Times couldn't have sent someone to Washington who believed in the First Amendment. And the ACLU, who had been on our side and filed briefs in our support, withdrew all their support because they found that was a totally inadequate answer from a First Amendment point of view. But after 16 days, we won 6-3, and the court's decision was that any sort of restraint on publication was unconstitutional unless the disclosures would surely result in direct, immediate, and irreparable damage to our nation or its people, and it was found that that standard wasn't met in that case. What happened to Ellsberg was stranger yet, and that was that he was indicted and charged with leaking the documents, which was clearly a violation of the Espionage Act. And he really was dead to rights, would have lost his case and been sentenced to 118 years, I think, up to 118 years. However, in the meantime, the Nixon administration had broken into a psychiatrist's office to try to get dirt on him, had not shared documents they were supposed to share by law with the defense side, and even went so far, apparently, as having a conversation with the trial judge in the case, suggesting he might be considered to become chairman of the FBI, all of which resulted in the judge declaring a mistrial and saying that the government had shown prosecutorial misconduct, and he threw the case out, which allowed Ellsberg to say that it was the happiest day of his life. Ellsberg, I should say, I met a year ago, and a very interesting guy, very intense. He was kind of lecturing me as to all the things we had done wrong in this NSA article. Why did we delay? He's been arrested many, many times for various forms of protest. I think he even was with Cindy Sheehan at the President's Ranch and was arrested there within the last year or two. Anyhow, I was talking to him, and then my 11-year-old son comes by and says, Dad, you said we were going to play football. And I said, yes, but here's, he has gray hair coming out. I said, here's Mr. Ellsberg, my son. And Ellsberg, without taking a break, takes a handkerchief out of his sleeve, and then another one, and then another one, and for 10 minutes does magic tricks that I didn't understand at all in front of my son. Totally unrehearsed. I mean, he had no idea that this kid was going to come up, right? To which I gave the only answer I could give, which is, now I understand how you got the papers out of the Pentagon. So anyhow, I think it's an interesting story, and it really does redound into understanding what's going on now in this kind of NSA article, which was followed by an article about the SWIFT banking repository, where again the government was getting the cooperation of European governments and banks to look into and to invade the privacy of private financial records of people in this country and abroad in an attempt again to track terrorist money. The Washington Post wrote an article about secret prison camps in Eastern Europe where torture was taking place. And all of these the government was very, very upset about. Now I should say that, many of you might say, well, who is it at the New York Times to decide what's injurious to the national defense? Isn't that the government's job? And I think that's a fair point, and that's why we collaborated and discussed this matter so much with the government, to try to get all the information they could give us as to why they felt this might be injurious. But in the end, much as one can say, well, the Times shouldn't arrogate that sort of role for itself, the fact is the only alternative to that is the government deciding what the press can or can't publish. And it seems to me that 200 years of history shows that we cannot allow the government to make the decision on what the public is going to know, because it makes it too easy for the government, therefore, to keep secret its own abuses, its own misconduct, its own unconstitutional behaviors. And if our history has shown anything, it is that the government does need, and our model of government is that there has to be oversight and monitoring of the government, and for it to be the final arbiter as to what gets out and what doesn't is to, I think, lead to much greater problems and much greater troubles than if an independent agency such as the Fourth Estate, such as the media, is the one doing it, as long as it does it responsibly and after consultation with the government itself. I just want to spend 5 minutes discussing one other case, which I think also has a huge historical background, and then open it up to some questions. And that is the greatest and most important libel case in our history, which is called New York Times v. Sullivan. And that was a case also that arose totally from a historical context, that arose from the civil rights movement in the South in the early 60s. The civil rights movement placed an ad in the Times which essentially had some errors about the abuses of the police chief and the police department of Montgomery, Alabama, in terms of beating up civil rights workers and blacks who were trying to work for their freedom. And they sued the Times. L.B. Sullivan, the police chief, sued the Times for libel, even though he wasn't named in that ad. An ad incidentally signed by Martin Luther King, among others, because there were some factual errors and the description of what the police did was worse than what in fact they had done. Now, Sullivan sued not only because he felt wrong, but more importantly because this was part of a strategy of the Southern establishment, the Southern segregationists, to essentially keep the media out of the South and allow them to do whatever they wanted without any sort of oversight from the media explaining to the nation what really was going on in the South. Because they thought if the public didn't know what was going on, they could continue heaping abuses on the civil rights workers. At that time, don't forget, the media was not anything like what it looks like now. The national media was essentially the New York Times, maybe the Washington Post and the Wall Street Journal, 3 networks. There was no such thing as CNN or Fox, and probably Time and Newsweek, and that was it. So if you could keep those 6 or 8 bodies out of Alabama, out of Mississippi, you could essentially do anything you wanted and no one would know about it. And so the strategy was to sue for libel, to A, heap huge financial damages on those companies. In fact, we had been sued 12 times, and in Sullivan's case we ended up losing $500,000. And the aggregate of all that, if we had lost about $6 million, was more than the amount of money money we made that year. So there was a huge financial toll. Plus, one strategy to kind of defend yourself is not to go into the state so that you're not subject to jurisdiction of the state, but that's exactly what they wanted us to do, not go into the state to be able to report on what was going on. So we lost $500,000 in a libel verdict because from a jury point of view, from a legal point of view, at that time all that had to be proven is that the report was false and it was injurious to the police chief's reputation. So the case was appealed by the Times to the Supreme Court, and the Supreme Court understood that that's really the legal basis was that, yeah, the Times should lose, but they felt that it was intolerable that basically this strategy was being used to censor the media and not allow it to report on these wrongdoings. So it went back to 1801. In 1801, the country repealed the Sedition Act. The Sedition Act was grew out of British law and basically said you can't criticize the king. Now it's strange that we had that in our body of law at that time, because I thought that was the purpose of the revolution, was to upset and change the British rules that existed. But it was in 1801 that finally was repealed, with the theory that in our country, in our new country, we want there to be criticism and public discussion about what our government is doing. And so the Times argument to the Supreme Court was, given that history of wanting criticism, of repealing an act that stopped any sort of criticism, the Times argued there's got to be some degree of breathing space to criticize government, and that you can't be liable if you just make the smallest mistake. But if you make good faith mistakes, you still should be okay, because we want to encourage that kind of debate, we want to encourage that kind of dissemination of information, not basically scare people into not discussing it. Now forget about the New York Times, but think of a small town in Utah where the newspaper publisher, let's say of a 7,000 copy paper, finds that there's wrongdoing in the mayor's office, that the mayor is getting kickbacks and bribes. And he wants to publish this, but he says, geez, you know, I'm 99% I got it right, but if I made a few mistakes and this guy sues me for libel, it's going to cost me hundreds of thousands of dollars in legal fees, it could cost me millions of dollars in liability, I'm going to be bankrupt, my newspaper is going to be finished, should I bother taking that risk? And the answer is probably not. But the answer from a public policy point of view is we want him to take that risk. So therefore the Supreme Court said, as long as he's doing it in good faith, as long as he doesn't have serious doubts about the truth of what he's publishing, we're going to allow, under the First Amendment, the purposes of the First Amendment in the Constitution, we're going to allow that sort of publication, even if there's some flaws, even if there's some falsity, as long as the falsity wasn't published with actual malice, with serious doubts as to the truth, or with a conscious awareness that what we're publishing is false, we're going to allow that to be okay. And that was the result of the Sullivan libel case, that the Times won because the plaintiff couldn't prove that we had somehow intentionally or with serious doubts published what turned out to be false. Now, that law later got stretched to celebrities. Public figures also have to prove that, and there are very good arguments about whether that's a good idea or not. You know, I mean, we want to spur speech about public events. Whether we also are trying to encourage speech about Britney Spears is, I think, a fair question. I just point out how this plays out. We're the only country in the world that has this sort of protection. We were involved in a lawsuit in Britain where we wrote an article about a leading restaurateur in London. London not known for its good cuisine, but we wrote about how this guy was bringing good food to London. We wrote an article about his background and said that he had had many a bout with drugs and alcohol. And he sued us saying that was untrue. So we went to the reporter. The reporter said, well, I got this out of his own biography. His autobiography says that he had gone on many a bender. And now bender is a Briticism, but it basically means, she said, sprees with drugs and alcohol. So we sent her over to explain how this, if this was a mistake, how this mistake occurred, that it arose out of her reasonable interpretation of his own writings. And she wasn't even allowed to testify in the case in London. Because the British law is the only thing that matters is truth. Why you made the mistake, what the reporter was thinking, whether she was in good faith or not, didn't matter. So she wasn't even allowed to testify. She was sent back over the pond, and we got hammered in the lawsuit. In fact, what happened was The judge says, you got to prove it's true, and there the burden is on the defendant, on the publisher, to prove the truth. So he went out to all the old bars that he had hung out at and said, isn't it true that he also did drugs? And so he came back to the judge and said, Judge, they're adding insult to injury. Now they're spreading the rumor that I did drugs. And we basically got hammered in the lawsuit. We've never lost a libel suit since well before Times v. Sullivan, and we've never settled the lawsuit since before Times v. Sullivan for dollars, but we lost big time for English pounds in that case. But it really illustrates the difference between a case we would win easily here in the United States and a case we lost over there. Now sometimes it has effects that maybe are overprotective of us, and I just want to finish by telling a story that we had in Utah, which was a case brought. We wrote an article about the Olympic Committee. This was in like 2001. I'm sure you all remember there were improprieties in the Olympic Committee here in Salt Lake City. And we wrote an article about, I think it was the treasurer or controller, I forget exactly whom, who was involved in some of these improprieties. And we ran a picture of this guy. Picture said, I forget the guy's name, Joe Smith. Let's run a picture of Joe Smith. So they went to the file department, picked out Joe Smith. Unfortunately, it was Joe Smith who was the former head of the Utah Senate, State Senate, but not the same Joe Smith who was involved in the Olympic Committee. So the Joe Smith in the State Senate, says, hey, why are you saying that I was involved in financial improprieties? I have nothing to do with these Olympic people. So he ran a retraction the next day, correcting our mistake. But nonetheless, he sued us. And, he had a sympathetic case, to be sure. I mean, he was an innocent victim to a mistake, no question. But we argued to the judge, and we won, that luckily he was a public figure. He was head of the state senate, or former head of the state senate. And because he was a public figure, he had to prove, again, because the Supreme Court decided that there should be some breathing space for us to make mistakes when you're writing about public figures, that he had to prove that we had serious doubts when we picked this picture. And while we were sloppy and we were negligent, and had he been a private figure, he certainly would have won the case. Because he was a public official, as a politician, he had to prove that we had doubts when we published, that we had doubts in our mind, and he couldn't publish that, so he lost the case. So sometimes the rule does serve to protect the press. Maybe one could argue more than it should, but I think in the end what we've decided, what this country has decided, is that to encourage public debate about public issues and matters of concern to the public is more important as a public matter than in certain cases protecting the reputation of individuals. I just want to finish out. Well, I think I'll stop right there. I was going to say a few words about the Libby case and Judy Miller, but I think I did that at the beginning. I would just say that as one who represented her, she spent 85 days in jail. She was criticized very harshly when she came out as to why she came out. She came out because Mr. Libby had given her a direct personal waiver, because Mr. Fitzgerald narrowed his scope of what kind of testimony he wanted from her. And she came out. She was very, unfortunately, unpopular among fellow journalists. She was very competitive, very aggressive. She also had written a lot about the weapons of mass destruction that was criticized harshly by liberals. And as a result, she was a very kind of unpopular reporter, despite her bravery, in my opinion, in her spending all that time in jail. And so it was an unfortunate kind of sequence of events, but I think I would give her a lot of credit for supporting the proposition that you just can't, you got to make every effort to protect your confidential sources, because really confidential sources usually are not the chief of staff or the vice president of the United States, but are usually people who the only way they can get their criticisms, their news out, if they're, let's say, middle management in a company, or they're critics of government policy, if they lend their name to a story, they're going to get fired. So the only way we're going to hear of criticisms of government, criticisms of big business, is if we allow these people to give them protection, to allow them to bring their news to the press, that the press can publish them without reporting their names, without identifying them, because otherwise they wouldn't come forward at all, and I think we'd miss a wide-ranging amount of context from the poor and from the powerless that I think gives our news reporting any sort of bite and allows us to criticize government and big business. Anyhow, I think I'll stop there, but I'm happy to answer any questions that anyone might have. Yes, sir.
What did you start out with in law? Like, how did you come to the position that you're in now?
I went basically to a law firm that did some of this sort of work. Cahill Gordon, which did represent First Amendment clients. And then from there, I got a job at the Times because they got to know me since I worked on some of their cases.
What kind of law did you initially start out? Like, what did you...
I actually did employment discrimination cases, and the Times had a number of those, and so I got to know a lot of people at the Times, and that's how they hired me.